Welcome everybody to our CLE put together by DVA Outreach Committee, and do we also have the labor and employment and bankruptcy and tax sections all together. This is about keeping pace with COVID, updates in labor, employment, bankruptcy, restructuring, and PPP loan forgiveness, all the matters that we're very excited to learn about. So I am the co-chair of DVA Outreach Committee, which is focused on networking and collaborations with professionals in other organizations and industries. Our mission statement lists the following goals: expanding our connections through interaction, expanding our vision of community through professional relationships, and connecting like-minded professionals through outreach. We're all about learning from each other and learning about each other and forming a very big community where we can work together and help each other. Our December meeting will go down on next Monday, December 21st, 2020. An RSVP link to our December meeting will be shared in the chat box. Please check it out and join us. And I am to thank the tax section sponsor, Hochman, Salkin, Tosher, Redtig, and Perez. It's a long name. Thank you very much for making this CLE happen. And you were sent a link via email to the written materials. Please check that out too. The panelists worked hard to put together the written materials, and I'm excited to have the CLE happen today. So take it from here, Ben.
Okay, just want to make sure everyone can see that. Welcome everyone. Thank you, Gina, for the great introduction. And thank you, Beverly Hills Bar, for allowing us to be a part of your day. My name is Ben Sheppard. I am a managing director in Green, Hasson, Janks advisory practice, specializing in economic damages and forensic investigations. And I'll be moderating today's lively session. Joining me today is Millicent Sanchez, a partner with Swerdlow, Florence, Sanchez, Swerdlow, and Wimmer, who will be leading us through some recent labor and employment legal updates. Next is Shectman, a partner with Danning, Gill, Israel, Krasnoff, who will give us some updates as to how COVID is impacting the world of bankruptcy and restructuring. We also have David Sutton, a colleague of mine, managing director in Green, Hasson, Janks Transaction Advisory Services practice and leader of the GHJ PPP response team. And to the extent that we have a few minutes, I'll provide some quick thoughts on how economic damages and valuation calculations may need to be rethought as a result of COVID. We're hoping to save a few minutes for questions, so feel free to forward them. If we have a chance to answer them during our presentation, we will do so. We have a lot to cover in a short amount of time, so let's get right to it, and then let's start with Millicent. So Millicent, first, we're all used to working from home for the most part, but there's still a lot of folks who are required to report into work. Where are we currently at with regard to how employees protect their workers from COVID, as well as how employers provide notice to their employees and stakeholders?
Hi. Yes, thank you, Ben. You know, as a labor and employment lawyer, having worked with our clients and companies and also small employers throughout this pandemic, helping them get, just navigate all of the stay-at-home orders and then the reopening protocols, the CDC guidelines, EEOC, Department of Fair Employment and Housing guidelines. I can honestly say that employers have been on the hot seat and they continue to be on the hot seat. They're constantly making decisions that impact how their businesses are run. These decisions impact their finances, the operations, and of course, their employees' livelihoods. And also they had to make these decisions on the spot without a lot of guidance as to what their legal obligations and risks are with regard to these decisions. And an area where there is a specific need for guidance has to do when employers have employees who become exposed in the workplace, or they understand that they have been exposed in the workplace. And as I said, there's not a lot of legal guidance, but what we do start with, and if I can have the next slide, is we start from the premise that employers have an obligation to provide a safe and helpful workplace to their employees. This is codified in the labor code. They also have an obligation to take all reasonable steps to ensure the safety, the health of their employees. A unique requirement under California law is that virtually all employers have to have adopted a written injury illness prevention plan for all their workplaces. And this would essentially, it's to identify and address workplace hazards, including establishing a procedure where they identify the hazard and address how they're going to correct the hazard. It also includes an obligation to have a procedure for for training your employees about these hazards and avoiding the risks, as well as just communicating with the employees about the hazards and establishing an investigation of these hazards. They also have to have written reports that are submitted. And especially, just to want to underscore, beginning in January 1, if an employee asks, they want to have access and know about these injury and illness prevention plans, the employer has to provide a copy of the plan within 5 days of that request. So that's a new one out there. And so some employers have kind of gotten away with not adopting those plans. You got to make sure that they are adopted and in writing. There are additional, now that COVID has truly been identified as a safety hazard, there have been some reporting requirements that have come out, and I'm going to talk about them. Of course, most of these do require or could involve separate presentations, but I'm just going to touch upon them so that you have them in mind and you can also answer questions later. But let's go on to the next screen and I can start off. As you all know, the state of California has a system that provides for a compensation and medical benefits to employees who are injured in the course and scope of their employment. And there's insurance that's set up for this. And who's administering the insurance is there's typically a workers' comp administrator that works with the employer to administer this insurance. Well, effective in September, beginning as of September, employers who either knew or reasonably should have known that an employee has tested positive, they're obligated to report to the workers' comp claims adjuster administrator a written in writing report to them in 3 days the date of that positive test, provide the address of the place of that employee worked in the 14 days preceding the positive test, and then also report to the claims administrator the highest number of employees that reported to work in the 45-day period preceding the date that the infected employee got tested positive. The purpose of this reporting obligation to the claims administrator is essentially to establish whether or not an outbreak of COVID has occurred. And the outbreak is a criteria I'm going to talk about later for establishing whether or not there's a presumption that any injuries related to COVID in the workplace are going to be presumed to be covered by workers' comp. Okay. So that's a new requirement, and employers are already subject to this. Let's go to the next slide. Right. Now, citing the spread of COVID in the communities, it's really essentially has been ravaging California as well as the other states, and citing the fact that a disproportionate number of COVID appears in certain communities, the Latino, Asian American, and Black communities, and that the average age of those who have been infected from COVID have become younger. The state legislature realized that we don't have enough data. There's not enough data that has been compiled to address the increase of COVID and helping the public as well as employees know where the outbreaks are occurring. So the legislature enacted this new bill, which becomes effective January 1. And it's a very significant one for employers because it does require employers to provide specific notices to their workforce, to their employees in writing with regard to exposures in the workplace. And it also requires employers to provide notice to the public health departments of any COVID workplace outbreaks. Okay, so this obligation arises if an employer has notice as to whether or not someone is diagnosed or test positive, or if an employee has been subject to a public health isolation order or has died. So in those instances, the employer must, within 1 business day, provide this written notice to employees at the work site. And I have work site in quotes because there's a specific definition in the statute that provides what the extent to which the exposures had to be provided notice to the other employees. So it's, for example, if it's a large employer where they have multiple buildings, multiple facilities, even multiple floors, that the employer may not have to provide this notice to company-wide, but may, if it, depending on the situation and how it comports with the statutory wording, they may need to provide notices of only to those employees who work in that particular work site where the exposure occurred, or the employee or the individual who had the exposure, walk through that area. So anyway, it's a very detailed reporting obligation because the employees have to be notified of the possible exposure, what the location is. They have to be notified of any safety precautions the employer is going to be implementing, as well as disinfecting plans. And they also had to be told as to whether or not there's any benefits available to the employees if they are also exposed, for example, paid time off or other benefits. If there's a union in place, the union also has to be notified. Again, that notice has to be provided within 1 business day of the employer's knowledge. In addition, if there's an outbreak of COVID in the workplace, and an outbreak is defined under this law as 3 or more cases within the 14-day period, the employer must also provide notice within 48 hours to their public health agency of this outbreak. And the information provided has to include the address of the business, the names of the infected employee, their occupation, the work site, and the date that they tested positive, and whether or not they were isolated or if they passed away. I just want to comment that this obligation is, as I mentioned, very detailed. And the last thing an employer wants to do or have to worry about is having to, to draft this notice consistent with the state within 1 day's notice and make sure it gets out in time. So we've been advising our clients that you want to, see if you can develop a template notice now, so that when it happens, you can customize it and be able to get it done and send it out and make sure that you meet the time requirements. Okay, let's move on to the next. Sorry. All right, as an example of just the continuing and rapidly changing landscape with regard to COVID impacts in the workplace, as well as the various guidelines employers have to adopt and adapt for their workplace. Cal OSHA implemented a new emergency regulation. They implemented and announced it on November 30th, and it became effective on November 30th. So we didn't get much notice in advance. But it's a very significant emergency rule. As I said, it became effective November 30th. It's going to be in place for 180 days. So this is something that, it's a Cal OSHA requirement. And if failure to comply can result in very substantial monetary penalties as well as potential criminal penalty to an employer. And I just want to add that they are still subject to revision, although my thought is probably not a lot of substantial revision, but there is a meeting to be held on December 18th, later this week, in which CalOSHA is convening an agency meeting with some industry and labor representatives just to get their thoughts of it. And so you have to, for employers out there, you want to make sure that you keep up to date to see if there's going to be any changes. These regulations are complex, very detailed. The agency has also issued a list of FAQs to help to understand the guidelines on your screen. I've listed some of the main highlights of the regulations. And I just want to, as I said, this could take, a couple of hours if you really wanted to go in depth. But I want to just make a few comments about some of the key ones for these purposes. First of all, there is an obligation to adopt a written COVID prevention plan for employers. Now, the employers that are covered by this are almost all employers, except for employers with only one employee who does not have contact with others, or employees who are working from home. This rule does not apply to them. And also employees that are covered by CalOSHA's aerosol transmissible disease regulations. And those are generally the healthcare facilities, laboratories, and other similar operations. So this rule does not apply to them. But there's a lot of us out there that does apply to. So listen to that very carefully. So you have to adopt a written COVID prevention action plan. And there is a model plan that's suggested by CalOSHA, and I've given you the website so you could take a look at that. But again, it's just a template, and it has to be customized for the particular workplace. The kinds of elements that have to be included in the plan include similar elements that's required by the injury and illness prevention plan, and then some that relate to specifically to COVID. So if you have an injury illness prevention program, it's possible that you can just customize that in accordance with this new temporary regulation. Now, as I also want to make a comment that when you prepare your plan, you also want to take into account any local public health work orders or public health orders, because, for example, the LA County Safer at Home and Reopening wage orders have additional requirements that must be included in this program. And, in reading the new plan, there are some inconsistencies with the plan if you compare them to some of the other county ordinances. So again, just want to make sure that when you put that plan together, that you're taking in mind the other requirements that a particular employer may be subject to. So some other comments. There's a section there about free testing. This new safety emergency temporary regulation requires that employers must provide COVID testing to all employees who are potentially exposed to COVID in the workplace. Now, those employees are permitted to get their tests during normal work hours. With respect to incidents, if there's a lot of incidences of COVID in the workplace or other employees, in other words, if there are 20 or more cases of COVID in the workplace and there were within the 30-day period, there are other rules with regard to free testing. With regard to the provision that requires employees to be excluded from the workplace, the employers must ensure that employees who have contracted, are symptomatic, or have been exposed to COVID are excluded until the return to work requirements that are set forth in this emergency standard are met. Now, importantly, some companies have established return to work protocols that include the requirement that employees get a negative test before they're allowed to return to work. This emergency standard now prohibits employers from requiring a negative test in order to return to work, but instead the CalOSHA requirement really focuses on the passage of time rather than testing. And there are, 4 categories where the time that this temporary standard focuses on. You look at whether or not the employee is subject to an isolation or quarantine order, or whether an employee has COVID and is symptomatic, or an employee has COVID but is not symptomatic, or if an employee is just exposed. So there's different time requirements must pass depending on those, those particular situations. I want to also make a comment about the requirement to continue employee pay and benefits. Under this standard, employees who are excluded from the workplace and are otherwise able to work, able and available to work, but for having to be excluded for COVID reasons under this temporary order, the employer must continue and maintain their pay as well as their benefits and their job status during this time period. There are some exclusions. For example, if the employer can show that the employee's exposure to COVID is not work-related, or if the employee is essentially out for a reason that's unrelated to protecting other employees in the workplace, then this requirement to continue their pay and benefits would not apply.
Go ahead, Millicent.
Okay, I know there's a lot to cover here, but I'm trying to get through it just a minimal time. The last comment I want to make is that, as I said, that CalOSHA has issued FAQs. So when you're working with this new guideline, there are FAQs to help to interpret the guidelines. But again, we want to pay close attention as to what's going on with CalOSHA on or after December 18th, if they're going to be making any other changes.
Thanks, Millicent. So just following up, there was something you mentioned before about recent California legislation impacting employers' presumed liabilities for their employees that contracted COVID. Would you please explain what those impacts are and how you would advise your clients about mitigating their presumed liabilities?
Oh, sure. Yeah, if we can move to the next slide. As I mentioned earlier, typically employees are eligible for workers' comp insurance, including medical care and wage replacement coverage, if they are unable to work because of a work-related illness or injury. And in the spring, Governor Newsom issued an executive order that provided for a presumption of workers' comp coverage for any illness that was COVID related in the workplace. That it was a rebuttable presumption, but that executive order expired in July, and the legislature responded 2 months later by enacting a state law that essentially established this rebuttable presumption of workers' comp coverage for any COVID illness. And this started, this covered the time period from July 6th. So there now is a rebuttable presumption of COVID of workers' comp coverage, and it applies to certainly the employees who are first responders and healthcare workers. And so there's a presumption that any illness, COVID-related illness or positive test would be covered by workers' comp if the employee tested positive within 14 days after they performed their work and they, at their workplace. In addition, for any other employees, there's a presumption of workers' comp coverage for COVID-related illness or death if certain requirements are met. Now, this would apply for employers who have at least 5 employees and the employee tests positive within 14 days after performing their work duties. It would not cover employees who work from home, unless that is they're working at a residence providing home health care to someone. In addition, the employee's test must be, the positive test must be part of an outbreak. And an outbreak of COVID defined under this statute is, it depends on the size of the workforce. And so if the employer employs 100 or fewer employees, if there are 4 employees who report COVID positive, then, you know, that would be considered an outbreak. If the workforce is larger, like 100, more than 100, and if 4% of employees are test positive within the 14-day period, then there would be a presumption of workers' comp liability. Now, I mentioned it's a rebuttable presumption, and if we can go to the next screen, the employer can rebut that presumption of workers' comp coverage, but they basically can do so if they've got measures in place that show that they have taken steps to reduce the potential transmission, or if they could show that there were other risks that caused the employees to test positive. So in terms of how do you prepare to see if you can rebut this presumption, this really underscores the need for employers to adopt their protocols in place, comply with their injury and illness prevention program, and add all the COVID prevention steps that are typically required under the state orders as well. So state, and that's also their local public health orders, and just following the CDC guidelines. But it's going to be very important to have a written program to be able to rebut this presumption. I also just want to, emphasize that under the state, under the LA County, if those of you under LA County shelter at home and safer at home protocols, the LA County has a provision in those protocols and in the specific industry guidelines that for everyone who can work from home, that they be directed to carry out their work duties from home. And that's a requirement under those safety orders, and you really need to include that in your safety plans as well.
So Millicent, have there been any changes? I think you mentioned something earlier, but have there been any changes to COVID paid sick leave?
Yes, actually there has been. If we can go to the next slide. I'm sure that you all know that under the federal law, there is the Federal Families First Coronavirus Act, which Congress passed in late March and became effective in April 1. And under that act, that employers are required to provide 2 paid leaves: emergency paid sick leave, as well as emergency paid family leave. Well, California also, and I'm sorry, that applied to employers with fewer than 500 employees. The leave the paid leave can be credited against the employer's federal payroll tax. So they had a tax credit they could use to fund that obligation to provide paid leave. California implemented a similar provision, but it applies to larger employers. It applies for employers of 500 or more. And this would apply to employees who are subject to state or local quarantine or isolation orders, or if the employee has been advised to by a healthcare provider to self-quarantine or self-isolate. It also implies if it's basically employees who are prohibited by working due to health concerns related to potential transmissions. And there's also a provision that relates to food sector and healthcare providers. Now, this paid sick leave provides for it's 80 hours, up to 80 hours of paid sick leave, similar to the federal law, and it's in addition to any paid sick leave required under California law. So this is something. In addition, the city of LA has a similar ordinance. So depending on where you or your clients are located, you want to make sure to see if there's in the particular county, there's not another paid sick leave requirement. But this is one that has also been implemented.
So Millicent, what about employers' obligations regarding family and medical care leave? What, if anything, recently?
Yes, a big one. I'm going to say, if I can go to the next slide. As many of you know that, I'm sorry, the next slide. Yeah. Both California and under federal law provides for family and medical care leave. And basically the current law, California Family Rights Act, provides for medical leave or family medical care leave that applies to employers of up to 50 employees. This is a 12-week job protected leave that employers of 50 or more employers must apply to eligible employees to care for themselves if they have a serious health condition or to care for a family member with a serious health condition. Well, effective in January, in just a couple of weeks, this family leave obligation will also apply to very small employers with as few as 5 employees. So this is huge in the employment area because implementing and administering these family leaves are very detailed, can be very complicated. And I have clients that have been obligated to provide these leaves since the 90s when the family leave rules first came down. And they still struggle with understanding whether or not particular employee is going to be eligible for the leave, how to administer it, and how to provide the correct documentation. So for smaller employers who typically do not have a human resources department who can handle these requests for leaves, they're going to have a very strict learning curve and a very short time period to get caught up. But again, this does provide for leave for employee serious health condition. There's a 12-week job protected leave. And so this is one that's very important for small employers with at least 5 employees and the larger employers to take heed of. Because the definition of the family members has also been expanded, this also impacts the larger employers who are currently providing family leave because now their policies have to be revised and they have to expand the scope of the reasons that this leave must be provided to eligible employees. One consequence of this is some employers have a new parent leave policies, which is there's a current law. It provides for a new parent leave for employers with between 20 and 49 employees, and many law firms have these policies as well as mid-sized businesses. Well, that law is going to be being repealed, is no longer in effect come January 1. But instead, you have to comply with the California Family Rights Act.
So Millicent, before I let you off the hook and we move on to the next section, I'm going to give you the $1 million question on the spot. So while we're so anticipating the rollout of the successful vaccines, how would you advise your clients about whether they can mandate their employers taking a vaccine?
Yeah, so I was watching the news last night and I was about to say that vaccines are right around the corner, but I watched the news last night and watched people actually get vaccinated. So of course it's very exciting and it provides a lot of hope for people as well as the businesses and employers. But the reality is that, it's probably going to be months before most of us are going to be vaccinated. But in the meantime, we have that all important question is, can we require employees to be vaccinated? There is no legal guidance that addresses this issue, but if we extrapolate from what the EEOC has talked about in terms of requiring flu vaccinations, the general rule, if you have at-will employees, that you can require vaccinations. But the question is whether you're going to want to, or employers want to just encourage or mandate, because there are going to be some exceptions. That, for example, if an employee has a medical condition or a qualified disability, they can ask for accommodation from this requirement. And if, for example, if they're able to perform the essential job functions without having to take the vaccination, then that's something the employer might have to accommodate. So if you have employees with medical conditions or qualified disabilities, it would be important to have an interactive conversation with them, kind of determine whether or not they can be required or whether we're going to accommodate it and allow them to work under other conditions, maybe working from home instead, rather than requiring them to be vaccinated. Another exception would be employees who have a sincerely held religious beliefs that would that would prohibit them from taking the vaccination. So again, this also requires consideration. And, so that is something that these are the kinds of things hopefully we can hash out soon, or maybe we'll get some legal guidance. But in the meantime, employers do, consider these obligations or consider these points with regard to whether or not you're going to impose a requirement to take a vaccine.
Thanks,
Millicent, I have a quick question from David Pierce. He is asking, how does paid sick leave apply when employee is able to work from home? Say when an hourly employee works at home, they have to record their actual time to be compensated, and they only record 5.5 hours rather than the 8 hours. If they were in the office and they're staying home because it's COVID related, caring for another, et cetera.
Right. Well, are you talking about this? Oh, I'm going to answer in terms of the Healthy Workers Act, the paid sick leave. Employers are required to provide up to, if they're under the state law, and I'm just going to segue that there are also some cities have their own paid sick leave provisions. But under the state law, it's 3 days or 24 hours of paid sick leave that's available. So if they're paid on an hourly basis, you're going to calculate the sick leave on an hourly basis.
All right. Well, thanks, Millicent. That was
You're
fantastic. So Zev, hi Zev. Let's hear you. So while we're thinking about these labor and employment issues, let's for the moment assume that a company is now having to make the difficult decision to contemplate bankruptcy. What are a couple of things employers should know about how their employees' claims may be treated in a bankruptcy?
Thanks, Ben. It's a pleasure to be here. Thanks for having me. And I'm happy to be talking about employment issues today, especially since some of my good friends are employment lawyers and I see them in the audience. So I'm happy to be here to talk about this subject. There's only one provision there's one major provision of the Bankruptcy Code that clearly deals with employee claims, and that is most commonly relevant in a business bankruptcy case, and that's Section 507A of the Bankruptcy Code, and that's a provision that provides different priorities in the waterfall of priorities under the Bankruptcy Code. It gives priority treatment to a limited amount of compensation that's up to $13,650 under current law for services by an employee within 180 days prior to the bankruptcy filing. This protection doesn't give an individual and employee that much leverage, although it does advance their claim ahead of other creditors in a typical bankruptcy case. There are things that larger companies need to be thinking about, which is the fact that employees in a larger company may be entitled to treatment as a class, and if there's a large number of these employees who are owed this amount of money, it can add up, and that could end up being a big part of a Chapter 11 plan that has to be dealt with, because it is entitled to priority. But it's really important to note that regardless of the priority of these claims, they come below secured claims in the waterfall of bankruptcy and don't get paid unless there's cash available that's not subject to a lien. There's other employment issues that come up from time to time. One of them that's kind of interesting is the WARN Act. And Millicent, could you tell us what the WARN Act is?
Sure. Do you have another hour? Basically, there's a state and federal WARN Act, and basically they require larger employers under federal under at least 100 employees, and for California, 75 employees. But it requires those employees, if they're going to be having a mass layoff or a plant closure, that they have to provide their employees, as well as the state agency and their union representatives of the plant mass layoff or plant closure. They have to provide 60 days notice of that closure, or be subject to substantial damages.
Thank you, Millicent. Ben gave me instructions not to be boring, so I'll try not to bore everybody with war stories. But we did have a hospital bankruptcy case a number of years ago where our firm represented the trustee in the liquidation of a hospital. There were a number of patients still in the hospital at the time of the bankruptcy that needed to be taken care of. And the trustee worked quickly and deftly to manage the orderly liquidation of the hospital case. The employees at a certain point after the bankruptcy filing were terminated by the trustee in liquidation, and ultimately an employee filed a WARN Act claim as a lawsuit in the bankruptcy case against the trustee. Under the law of under applicable law in this case, the Century City Doctors Hospital case, the court dismissed the lawsuit because it concluded that WARN Act does not apply to a liquidation bankruptcy, and that decision was affirmed by the bankruptcy appellate panel of the Ninth Circuit. It's a different story if we're talking about an operating Chapter 11 case where a violation of the WARN Act occurs, but that's not the case of Century City Doctors Hospital, which I believe is a published opinion. There's another thing that I just wanted to throw out there that some of you know well about, much better than I do, which is the Private Attorney General Act, PAGA. And it's just interesting to think about how PAGA plays out in the context of bankruptcy, because there's something called the automatic stay, which prevents most types of proceedings to occur in a bankruptcy case, but there's an exception for governmental authorities. And some people might argue that a Private Attorney General Act claim is a governmental action. However, I believe the state of the Ninth Circuit law is that a PAGA action is subject to the automatic stay, but the exception to the exception to the exception may be if it's for a health and safety reason, something that is not pecuniary in nature, where the action seeks to, let's say, enjoin some violations from occurring, not demanding money. That may be an exception subject to further analysis. Thanks, Ben.
Yeah, so let's move on to the next subject. So how did the CARES Act impact small businesses contemplating bankruptcy?
So probably the most important change, and if you can move to the next slide, please. Prior to the pandemic, Congress enacted the Small Business Reorganization Act in 2019. It became effective timely in February of 2020. It provides for a subchapter 5 or V of Chapter 11 of the Bankruptcy Code. Chapter 11 is reorganization. Subchapter 5 provides for a small business reorganization. And when it was initially drafted, a small business was limited to about $2.7 and a bit million of debt. What the main thing that Congress did to, utilizing the bankruptcy code in the CARES Act was it increased the debt limit from 2.7 and a bit to 7.5 million, which covers a lot more significant businesses when you think about the debt that a firm would have. The bankruptcy court, the chief judge of the bankruptcy court reported just about a week ago that the utilization of this new subchapter 5 has been good. That there's been, I think, over 80 cases filed in the district, the Central District of California, and that they're anticipating more. The main features that make this subchapter 5 attractive include several provisions of the code, changes to the code that make this streamlined version of Chapter 11 less expensive, less onerous, and easier overall for small businesses to get through. One of the major critiques of Chapter 11 for small businesses was that it just had too many hurdles for small businesses to overcome, and that it was very expensive and risky. This subchapter 5, streamlined Chapter 11, only allows a debtor to file a plan. There's no competing plans. It's supposed to be quick, so it's supposed to be done within the first 90 days of the case. There's less of a problem or concern about the owners keeping their equity in the company, whereas in a normal Chapter 11, you have to go through there's a challenging process for a shareholder, for an owner of a company to actually end up with the company at the end of the day. They have to provide new value. That's not necessarily the case. That is not the case in a subchapter 5. The owner is expected to stay in control of the company and it does not have to satisfy what we call the absolute priority rule, which is, everybody else needs to get paid in full before the owner, him or herself, can end up with the company. And probably one of the most obvious features, or among the most obvious features that make subchapter 5 less onerous, is the absence of a committee and no requirement to file a disclosure statement. A creditors committee is comprised of some of the larger unsecured creditors of a debtor. It can be a very valuable part and helpful part for creditors. They sometimes can be very collaborative and help a company succeed. Sometimes they can be an aggressive adversary in a Chapter 11 case. Either way, it costs money because the professionals of the committee get paid from the assets of the company, and that does not exist in subchapter 5. Same thing with disclosure statements. So typically in a typical Chapter 11, you first have to provide adequate disclosure in a disclosure statement, and there can be litigation over whether disclosure is adequate that lasts several months before you could even go and propose a plan or get to the point of seeking votes on a plan. So the subchapter 5 dispenses with that requirement altogether. Instead of a committee, there's a professional trustee whose job is primarily to facilitate, and which I think most of us interpret as helping out and help and kind of helping see the business debtor through a plan. It's a lighter touch kind of oversight than you might see in other types of bankruptcy.
So we have a few minutes left. So what have we seen from the bankruptcy courts and how they're responding to certain COVID-related issues?
So if you turn to the next slide, there's some information. You always go to the website. The bankruptcy courts are officially physically closed, but they've always been open. We've got e-filing, we've got Zoom. The chief judge reported there's been over 2,000 Zoom hearings or video hearings since COVID-19 started. So we are open for business.
So before we turn to David to talk about PPP loan forgiveness, I'll ask you about the PPP loans. Are bankruptcy debtors eligible for PPP funds?
Depends who you ask. The SBA says no, but some courts say the SBA is wrong because they are violating federal law. Others disagree and say that the SBA could keep on discriminating and acting arbitrarily and capriciously as against debtors seeking PPP monies. You can see where my opinion is.
I was about to say so. Yeah.
And we'll see. Maybe it'll go up to the Supreme Court because there's been dozens of decisions and they're all over the place on these issues.
Awesome. All right. Well, Zev, thank you very much for that update.
My
David,
pleasure.
hi. Thanks for being patient. Let's talk about PPP funds. So, as for the current state of loan forgiveness, what's the latest news you've heard about how companies are able to apply for PPP loan forgiveness?
Yeah, absolutely. And there's a couple of kind of sub answers to that question. And so I'll give a kind of overview of where we are in terms of the process for applying, a couple of thoughts that we have, and then items that are on the horizon as well. So the Flexibility Act, which is the first bullet I have here, is in full effect, and I think was very well received by most borrowers. It covers all borrowers, and it's really aimed at increasing dollars that would be forgiven under the forgiveness process, and relieve some of the administrative burden potentially that might have existed as well. So very favorable development from a borrower perspective. And I, albeit that act is somewhat aged, it was a few months ago now that it came into effect. The reason I'm talking about it is because, on the other hand, you have this SBA questionnaire that was published earlier in November, and it was published for public comment and feedback. And at the end of November, that feedback window closed. But the SBA questionnaire is somewhat different in the sense that the questionnaire is aimed at borrowers who borrowed more than $2 million, and really digs into questions around their eligibility, how funds were used, how the business performed during the period that the loan was in place, etc. So on the one hand, you have the Flexibility Act that was really favorable to borrowers, and then on the other hand, you have the questionnaire, which has spooked some borrowers, quite frankly. So a little bit of disparity depending on who you're talking to about PPP and the forgiveness process. What the questionnaire is, it's written with, or it's written for the borrower to answer with the benefit of 2020 hindsight, versus the original application was based on significant uncertainty that existed at the time of application. And those two things are obviously very different in terms of how you look at the PPP, how it was used, and whether the business really needed that funding. A couple of thoughts that I would add there is the questionnaire, for folks that have not seen it. First and foremost, it's not official yet, although I have seen some lenders actually sending it out to their clients and their borrowers. It's not yet officially launched by the SBA. You can find the document online with a quick Google search, and we can provide a link to it as well. But the questionnaire is very factual in terms of the questions that it asks and the answers that are needed. There is a handful of areas where there's open text comment, and what we would actually encourage is for folks to really make use of those and put in relevant information that refers to how the funds were used and really justify the need for the funding in those free text boxes.
And David, let me jump in. So is that
Yep.
threshold in terms of the justification, is that still set at $2 million, or is that different now?
It's $2 million, meaning borrowers who apply for and receive more than $2 million will be subject to audit. Folks who borrowed less than $2 million will be deemed to have met the good faith certification that was made on the application form, that sufficient uncertainty existed, and therefore that's the gateway to eligibility for the loan.
So in terms of advising companies, when would you advise them to submit their loan forgiveness applications?
Yeah, that's a great question. And up until maybe 2 months ago, I might have said, hold for now until we see how things will develop in terms of future stimulus, in terms of the pandemic itself, and so forth. Plus, a lot of lenders were not really accepting applications at that time. Now what we're seeing is that lenders are opening their portals to allow borrowers to submit applications. We know that the pandemic is going longer than everybody thought it might do back in March. And then also elements of tax deductibility and so forth, which are all now becoming clearer. The general thesis now is that if you think you're going to achieve full forgiveness and there is no mitigating reason to delay, then go ahead and apply for the forgiveness now and get in that queue, and it'll be processed and so forth over time. But to really go ahead and submit when possible.
And last question: how are we on the future stimulus talks? What's the latest you've heard?
Yeah, it's still unclear. There is legislation that's going through the various approval processes right now. And the insight that we have is that that additional stimulus package might include another round of PPP. It might include tax deductibility for funds that are, for expenses that are met with forgiven PPP funds. So currently, you cannot deduct, for example, payroll if it's covered by forgiven PPP funds. That may change. We're hoping, expecting something in the next 2 weeks, maybe over the holiday period, early into 2021, as to really seeing what that stimulus package will look like. So it's a little bit open, but we do have a couple of insights.
So that gives us room to get you in front of the crowd again, David. All right, awesome. I know we just have a couple minutes left, and I wanted just to briefly go over some thoughts about how COVID is impacting economic damages and valuations. I want to try to run through this real quickly. I think just in total, what we're looking at is, there were some, I guess, foundations that experts such as myself would go through in terms of, let's say, applying the historical approach or historical numbers and seeing if that can be used as a suitable proxy for future operations. And you typically try to apply that. I think in this current situation, we have to rethink the whole thing. Have to put a lot more thought into whether the operations themselves have changed. Like for restaurants, maybe they're going to a more defined menu. They're trying to make more turns. So the whole nature of their operations have changed. And how long until the operations return to normal, knowing what normal might be. So that creates a lot of additional risk in the calculations, a lot of uncertainty. And so I think, you still have room to be able to create these damage calculations or these valuations and looking at future issues. But I think the expert has to try to provide more room to be perhaps conservative and allow for different scenarios. We're not experts on how companies are going to be responding to the pandemic. Although I think that as the vaccine rollout proceeds and we see how the economy and we see how individual companies are responding to whether or not they are able to come back, I think this issue might become a bit more fuzzy. But until then, I think there's some things that we can do, perhaps present ranges for different alternatives, and perhaps make the analyses themselves more conservative by potentially considering lowering the expectations or increasing the discount rate which recognizes the additional risk in achieving the other projections. So again, it makes the analysis more conservative, but if we're all trying to get to the right answer, then that's something that we may need to consider. So Gina, I know we're just almost out of time, but do we have any questions for the crew?
No more questions. So final thoughts?
Any takeaways, guys?
Yeah, I've got something. Although Millicent, go ahead. You're on mute.
I am. I just want to say, like in the employment field for employers, the only constant that we have is change. And so we have constant changes in the you know, the county orders and what employers have to do. So it's just having to be flexible and, you know, be ready for change.
Okay, yeah, my advice for people who are thinking about bankruptcy issues, and I see I've got a couple colleagues on here, and I hope they agree with me. The bankruptcy chief judge mentioned at her State of the Court address on the 7th that the staff of the court is down because bankruptcies have been down for a number of years prior to COVID. And because of the way that the federal bureaucracy works, the bankruptcy courts, even though they expect, in her words, a flood of bankruptcy cases, the budget hasn't been modified to address that. So it's going to be really important for people who are filing business bankruptcy cases to have good attorneys, good counsel, to be prepared in advance. Don't wait for the last minute. You know, I think the court has a lot of, I mean, it's a court of equity, so it does have sympathy for people who are in dire straits, but that doesn't mean they are okay with people not following the rules carefully. And there's a lot of good information on the court's website. Use it to your advantage. And call a good bankruptcy lawyer, and you know, make sure you have an expert team on your side when you're getting ready for a bankruptcy filing. And it's never too early to start talking, because if you wait till the last minute, you're more likely to mess it up. And with more limited resources, the judges, notwithstanding COVID, may have a little less patience for shenanigans.
David, any last thoughts?
Really that, you know, disruption and continuing change, as Millicent referred to, is a breeding ground for opportunity. So from a business perspective, this is disruptive for a lot of folks and individuals. At the same time, there's a lot of opportunity that's coming about through that disruption. So it's not all doom and gloom out there for individuals and for businesses as well.
Yeah. I would agree. I mean, if our business model is based upon change, then perhaps there's no better time to be in business for us. So I wanted to thank everyone for your time and attention. Gina, any final thoughts?
Yeah, this has been very informative and fun. And we started out with about 53 participants quarter-to-1, and we still have, and at maximum we had 64, and it's almost 1:35, and we still have 61 participants.
Well, let me
very
throw
telling
out
of how great the program has been.
Well, that's fantastic. Well, let me throw out, I mean, obviously, I mean, we've included our bios at the end of the presentation, which should have gone out to everybody. So feel free to reach out to us if you have any questions, you know, or you just want to bounce some things off of us. You know, we are all available to help. So thank you very much.
Thank you. Thanks to Ben for putting this together, and all the panelists, Zev, Millicent, and David, and also the HBA. And we're having our outreach committee meeting next Monday. Please come join us. There is a chat box link to the registration, and we will talk about more issues like this, more topics that everyone could be interested in. Thanks very much for participating, and thanks very much for paneling. Thank you.
Have a great day. Bye, everybody.
Thank you.
Thank you, everybody.
Thanks,
Just as a technical reminder, all the attendees should have received the link to the materials, to the program materials and slides in a 1-hour email reminder. And also it was in the chat. And also thanks again for this informative webinar. Thank you to our co-sponsors, Hochman, Salkin, Tosha, Perez, and have a great day.
Thanks,
Bye-bye.
Alex.
Bye-bye.
Bye-bye.
Thank you.
Thank you.